The renvoi doctrine, a procedure whereby a jural matter presented is referred by the conflict of laws rules of the forum to a foreign state. The conflict of laws rule of which, in return, refers the matter back to the law of the forum or a third state. It is a French word which means refer back or return. So what are conflict rules in wills and administration of estate? There are two theories in determining the proper law for the transmission of successional rights. One is unitary or single system, and two, split or scission system. In a unitary or single system, only one law determines transmission of real and personal property. For example, in countries following lex nationality, like the Philippines, deceased national law governs. In common law countries, those that follow lex domicili, the law of the deceased domicile governs. In split or scission system, they follow as to real property, lex situs, and as to personal property, the law of the domicile. This is adopted by the Great Britain and the United States.
Now, let's talk about extrinsic validity of wills. If the will was made by an alien abroad, its extrinsic validity is governed by either lex nationali or lex domicili or Philippine law or the lex loci celebration. If it is made by a Filipino abroad, its extrinsic validity is governed by the lex nationali or lex loci celebration. Third, if the will is made by an alien in the Philippines, its extrinsic validity is governed by the lex nationali or lex loci celebrations. In all these cases, however, we must note that the extrinsic validity is dependent on the observance of the law in force at the time the will was made.
We will now talk about the intrinsic validity of wills. When it comes to the order of succession, amount of successional rights, and intrinsic validity of the provisions of the will, we follow either of the two. Lex nationali of the deceased for countries that follow the nationality theory, regardless of the location and nature of the property. Or lex domicili at the time of death in countries that follow the domiciliary theory. In case of conflict between the two, the case can be treated as a renvoi to apply the Philippine law even if the deceased was a citizen of another country. What about the capacity to succeed? We follow lex nationality of the deceased and not that of the living.
Probate of wills made abroad. The general rule is lex fori because allowance or disallowance of a will is essentially procedural. If the will is not yet probated abroad, lex fori of the Philippines applies as to the procedural aspects. That is, the will must be truly probated here and the due execution must be shown. Already probated abroad, lex fori of the Philippines again applies as to the procedural aspects. The will must also be reprobated here because a foreign judgment cannot have extraterritorial effect as a general rule. But instead of proving execution, generally it is enough to ask for the enforcement here of the foreign judgment of the probate abroad.
What about revocation of wills? If revocation takes place in the Philippines, whether the testator is domiciled in the Philippines or some other country, Philippine laws apply. If revocation takes place outside the Philippines, by a testator domiciled in the Philippines, Philippine laws apply.
What about if the revocation is done outside the Philippines by a testator who does not have his domicile in this country? We apply either of the two. First, the law of the place where the will was made, or second, the law of the place in which the testator had his domicile at the time of the revocation.
autonomous states. Like probate, administration is procedural in nature. Philippine law and procedure follow the main principle of bilateralism. The law of the domicile governs distribution, but the law of the state, appointing the administrator or executor, governs administration. Administration is governed by the law where administration takes place. That is the law of the country from which the administrator derives authority. We note that the administration extends only to the assets of the decedent found within the state country where it was granted. To administer the property situated in a foreign state, the administrator must be reappointed or a new name in that state.
If a person dies in the state, in civil law countries such as the Philippines, lex nationalis is followed. In common law countries, split or scission system is followed. What are fiduciary rights? There are two theories adopted by states to claim properties left by the deceased with no heirs and no will. In some civil law countries like the Philippines, the state is the last heir of the deceased person. Hence, the state succeeds to the properties left by said deceased person as an heir. In England and most American countries, said properties become vacant and ownerless and should revert to the state where they are situated by escheat.
Torts. General rule, lex loci, delicti commisi, or law of the place where the tort was committed will govern. Why? The state where the social disturbance has occurred has the primary duty to redress the wrong or determine the effects of the injury, to compensate the victim of the damage or injury suffered. Concepts of place of wrong or locus delictis. Common law concept. Place where the wrongful act became effective. Example, the last event necessary to make an act liable for an alleged tort act. Civil law rule. Place where the tortuous act began. Theory of Dr. Rabel. Place where the important and substantial acts leading to the tortuous act were committed, or place having the most substantial act connection with the wrongful act.
What are the modern theories in determining liability for torts? 1. The theory of most significant relationship. In this theory, an action for tort may be filed in the country that has the most significant relationship to the occurrence and parties, and thus has the greatest concern with the specific issue of the case. 2. The interest analysis approach. This theory considers the relevant concerns that two or more states may have in the case. The state which has the more relevant and weighty interests in a case should be considered the locus delicti. Number 3. Haber's principle of preference. A higher standard of conduct and financial protection given to the injured party by one state is applied by the state where the injury happened. If the latter state adopts a lower standard of conduct and financial protection to the injured. Number 4. The German rule or elected concurrence. In this theory, the injured person may choose to sue either under the law of A. The place where the actor engages in tortuous conduct, or B. The place where the effects of his conduct occur.
Enforcement of claim for foreign tort. An action for a foreign tort may be brought in any place where the tortfeasor may be found, so that he can be subjected to the jurisdiction of the court. There are three conditions for the enforcement of tort claims. First, the foreign tort is based on a civil action and not on a crime. Number 2, the enforcement of the tort would not infringe the public policy of the forum. Number 3, the judicial machinery of the forum is adequate for its proper enforcement. It is important to note that while all procedural matters are governed by the Lex 40, all substantive matters are governed by Lex Loci Commissio.